topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Good morning. No, I'm sorry. I've been doing this lately. I've got so many morning shows across the country. I've been going good morning for every show now. But you know what? It's easier to say good morning than it is good afternoon. But welcome to another Ask the Experts, where we bring you the finest experts in the fields of legal, health, financial, and home improvement. We welcome you to our TV show today. It's the last Thursday of the month, and that means K. Bender Rimbaum. Now, what we did was we took a survey from homeless people on who they would like to see on our show. I'm kidding. I can't even do this with a straight face. Let's welcome Alan Schwartz-Seed.
Schwartz-Seed, you almost got it this time. I'm impressed, Steve.
You know what? When you have a name like Oschwanger, man, it's nice to be able to make fun of someone else's name. But I got to tell you, you and I have this great rapport, and I love the way you answer questions. Our show today is about community association law. And if you have a problem with your association, there's several ways that you can reach us. You can reach us on our chat line, which is right next to if you're watching us on TV. If you're radio, we have actually got a phone number that we can give you. It's 561-623-9429. That's 561-623-9429. Now, between shows, the first and the last Thursday shows, we open it up by letting you text us with your questions. And we must get about 25 to 30 questions each month that we will be reading on air. So there's three ways. You can either ask your question on our chat line on TV, W4CY.com, or you can call us at 561-623-9429. And we will be answering questions, anything you have that involves association law. Alan, we have so many new people every week that are joining our show. Tell everybody about K. Bender Rimbaum.
I'd be happy to do that. Thanks, Steve. I appreciate the opportunity. So our firm is based in South Florida, but we've got offices now in Palm Beach County, which is still South Florida. My office is in Orlando. We've also got an office in Tampa. We've got 21 attorneys, 9 of whom are board certified in this area of law, representing community associations. That's all we do. So when you need representation, you need to know something about how a community association is supposed to operate, we're the people you contact. Like I said, we've got 9 board certified attorneys. For the people that are in condos that are just turning over or have turned over recently, we've also got an on-staff construction certified attorney. And I'm proud to be back with the firm, having worked with them from 2010 to 14. And, now I've seen that the grass isn't always greener, and I'm happy to be back and found my permanent home finally.
Well, K. Bender Rimbaum has got probably the greatest reputation in all of Florida. Every time somebody, a law firm who says they practice a community association law, and I tell them we have K. Bender Rimbaum, I've never had a negative thing said which is nice because you know how attorneys are. Oh, you have them? Well, let me tell you about them. Can't do it with K. Bender Rimbaum. They're just first class, and I understand why you came back.
I appreciate that. Yeah, I can't really disagree with anything you're saying, Steve. And frankly, that is a big reason why I came back. The firm's got a stellar reputation. I respect, especially, Mike, Robert, and Jeff, and have stayed in touch with them even after I left and after I left South Florida. And I'm just very glad that it's worked out and get to meet great people like yourself and hopefully give some more people some unpaid guidance that they can't rely on today.
This guy is such a suck up, I got to tell you. But we love him, though. So we got to get to the questions. We've got so many questions.
Let's do it.
You know what? This is the first month that I have not gotten a question from a resident that at gloom and doom. And you know what I mean by it. People are nervous about what's going on. Everything is going up. And I don't know. This is the first time, which I was so happy that's happened. And I wanted to ask you, give me your personal feelings on these new statutes now.
Well, some of it's going to be helpful. There is a bill that is in progress right now that would revise the former Senate Bill 4D, which is now law, and would kind of clarify a couple issues. It was discussed in depth at this week's condo committee meeting of the Florida Bar. Probably not as much depth as some of us would have liked, but the bottom line is, Allison Hertz of our firm is very well versed in 4D. I was on the committee that was trying to clean it up with her, and it looks like some of our recommendations have been taken by the legislature, and they're actually taking a serious look at, like you said, the gloom and doom and how this really is going to impact people. We're hoping that this bill that's pending right now will actually be revised again, because of course, once you introduce changes that aren't necessarily what the attorneys that practice in this area of law are recommending, you end up with additional glitches that then need to be fixed. But, the bottom line is we're hoping for a little bit more time for people to comply, a little bit more understanding of what some of these statutes even mean, how they're going to be interpreted by the DBPR when it comes to, their governance over condominiums. But there have been, some bills. There's one in particular. I can't recall the name or the number offhand, but it is pending in the Senate. And it would, I don't want to say clean this up a little bit, because frankly, it doesn't do remotely enough to clean up what we've got right now, but it helps. And there are some things that it'll help, some that it won't. I'm especially hopeful that there will be, additional people that are authorized to do these reserve studies, and the SIRS and MERS is what I like to call it, and that there will be people that can do this under the supervision of others, so that all the condos that are required to get this done and the co-ops that are required to get it done will actually be able to comply with these new laws within the not really large time they're given. Another almost 2 years sounds like a ton of time until you realize that people are already backed up 5-6 months with reservations, so to speak, to try and perform these reserve studies. And so we're hoping that it'll get cleaned up, but no promises.
Well, I'm kind of the gatekeeper of these texts that come in, and it seems like people are worried about reserves and assessments.
Well,
assessments going up.
Here's one of the things, and I know Jeff Rembaum talks about this fairly frequently. The current status of the law doesn't really allow an emergency special assessment unless there is a declared state of emergency separately. But it's not considered sufficient to get a loan, get a special assessment, if you don't have the authority to do that in your governing documents. In almost every community, this reserve, this additional reserve, the cost of the studies themselves is going to make your budget skyrocket. And so a lot of them, they're not going to be able to just tack this stuff onto the budget. So it's kind of a double-edged sword with respect to what you're saying and what I'm saying. Yes, assessments are going to go up, The concern is almost that you won't be able to increase the assessments and you won't be able to get the work done that these studies say you need, or you won't be able to fund them to get them done in the first place. And then your association's in violation of the statute, and potentially, your directors and officers are in violation of their fiduciary responsibility. So it's, that's part of, listen, I could go on the entire hour that we've got talking about what a mess this is and ways that I like to see it cleaned up. But the bottom line is people have a right, and frankly, they're not wrong to be concerned that these assessments are going to increase. What I'm hoping is that the legislature will understand that, because we've all been telling them since this all went into effect, you got to provide some kind of relief for these people that are going to be kicked out of their homes because they can't afford an extra, I think we mentioned this last time I was on the show, some of these, it's going to be a $5,000-$10,000 reserve study for a relatively small condo, plus the cost of doing any work that you wouldn't have even thought you need to do. Now, listen, This is a life safety issue. It's necessary. I think there needed to be some kind of legislation. But as we've discussed previously, I just don't think this was it. I'm hoping that it'll get cleaned up this year. Or, the good news is we've still got the next year's legislative session and potentially one later this year to clean this up and figure out how to make it so that people can actually comply with what they're supposed to do without people being kicked out of their homes instead of their homes crumbling.
I'm going to go to Kyle in Boca. He wanted to know, what would be a reasonable price for an attorney to add the Kaufman language to their documents? Our complex has 12 condominium buildings and a master association HOA group discount.
I mean, I wouldn't say there's a group discount that would be available for most community association attorneys. What you might be able to do, if the declarations are drafted similarly, and, for example, I represent a community where there are 5 phases, 5 condos, but every single declaration is identical except for the name of the community, the size of, the amount of units and things of that nature. If those minimal things are all that needs to be changed from one document to the next, it may be, a minimal charge for additionally looking at it. I mean, I've done amendments for $1,000 per condo, but keep in mind, it's that $1,000 for the first one. That's a low figure compared to 90% of attorneys that are doing an amendment. And that was a fairly straightforward one. I mean, this is too, all you're really doing is adding language. And just for anyone that doesn't know what this Kaufman language, it incorporates the Condominium Act as amended from time to time. And that's crucial because it determines whether a statute that is changed later on is going to actually apply to your condominium, or if your declaration is going to control over the statute. So bottom line, I can't give a straight answer to this one because I don't know. With the question asked, I can't really tell. You say the governing documents. Does that mean the declaration? Or are we talking about declaration, bylaws, and articles of incorporation being amended? I don't think your articles would be amended for that purpose, but some developer attorneys put weird language in those articles of incorporation that really does govern the operation of the community beyond this is what this community was formed for. So I would say it really depends. When you're talking 12 condo decks, if we're saying just the declaration, I would say add another 20, 30 minutes at a minimum for each one of those of the attorney's time to take a look and make sure that the provisions that are being changed are actually the provisions you want changed. Now, keep in mind also the quote that I'm giving, without giving an actual number, also presumes that you've already discussed what this Kaufman language would actually mean for your community. Because the reality is you don't always want the statutory changes to be incorporated into the way that you need to operate your community. You might want to have the argument that the new statute doesn't apply. For example, some of the things regarding Senate Bill 4D, I wish I could make a reasonable argument that my clients don't have to comply because it's a retroactive application of the statute. It basically, the reason that this works this way, the Kaufman language, is because changes to the statute that change the way that the community operates are changing your contract with the community association. And you have a vested right to have that contract stand as is. So there are certain things that'll change if a statute changes, and certain things that won't, based on whether that Kaufman language exists or not. So bottom line, I can't give an estimate without more information.
Understood. Very important, though, to know, have a law firm handle this for you, like a K. Bender Rimbaum. Don't try to do this yourself.
Yeah, I will say I've encountered multiple people who were on boards of directors and were knowledgeable, but looked up Kaufman language and said, oh, we got to incorporate this, but didn't realize that means that most statutes will now apply no matter how many times the legislature screws it up. So that may not be really what you want. And that discussion could be, another half hour to an hour. And it should be had. It should be something that the board seriously considers, rather than just presuming that the newest version of the statute is the best and brightest.
Let's go to Brad in Boca Raton. He says, I love your show and I never miss one. Oh, those are the kind of people we love. On January 1st, 2025, the association's budget must contain reserves for 10 different categories. Can you please identify what the 10 categories are?
Probably. Let me look at my notes. All right. Okay. You've got your roof, your load-bearing walls and other primary structural members, the floor, the foundation, fireproofing and fire protection systems. And yes, I'm absolutely reading this from my notes.
That's okay.
I've memorized this. The plumbing, the electrical systems, waterproofing and exterior painting, windows. And here's like the catch-all is what I call it. Any other item that has a deferred maintenance expense or replacement cost that exceeds $10,000 and failure to replace or maintain that item negatively affects the other items listed above. So if it's going to impact the roof, load-bearing walls, etc., you're basically going to have to reserve for it, even if it's not one of those things, if it's going to impact those things, and the cost of doing the work would cost more than $10,000. Now, the $10,000 figure, I think it might be a little low, because most communities can come up with 10 grand if they really need to.
Yes.
But the bottom line is, this is what's in the statute right now, and you have to comply with it. When it comes to the date, there is, room for interpretation on when you actually have to have reserves fully funded. If you didn't have the reserve study done, for example, until November, or let's say December 31st or December 30th of 2024, you're probably already going to have your budget in place for 2025, and you didn't know what the engineer or architect who performed that reserve study thinks needs to be done with your building. So there's an argument that if you don't have that study done until just before the deadline, technically you might not be required to have those fully funded reserves for the purposes of that reserve study until the following year, 2026's fiscal year. I don't recommend relying on that, because we have no idea how a judge or the DBPR will interpret it, but it is one interpretation.
Hey, let's go to our phone lines.
All right.
Jean from Delray Beach. Hello, Jean.
Hi. Thank you for accepting my call. My question is regarding assessments. How does a board go about applying an assessment to the building owners? It was regarding a case, this would be the deductible in an insurance case that the building is responsible for paying. And how would you apply that if you want to do an assessment for that deductible to the whole building, to all the owners? How do we go about doing that legally?
Well, there are a couple different answers there, depending on what you mean by an assessment. You've got your maintenance assessments, which are just your budget split among the amount of units, or however it's split within your governing documents, and then divided by the amount of installments per year. And that's how you come up with your maintenance assessment. That's just your budget divided by whatever you've got there. If you are able to use funds that you've already got and then incorporate that event into your budget for next year, then yeah, you don't need a separate assessment. What I presume you're talking about, though, is a special assessment for the purpose of paying an unexpected expense. And frankly, you're just going to look at your governing documents, see what they require. It's probably going to be either in your declaration or bylaws, most likely the bylaws and the assessment section. The declaration will probably provide the authority to levy it. The bylaws will probably say how you do that, but the declaration may do it anyway. And if it's in there, then those documents will tell you. It's not a clear statutory definition of you must do this. The only thing the statute is clear on is that you need to provide a minimum of 14 days notice of the meeting when that special assessment is going to be considered. And also that notice needs to clarify what the purpose of the assessment is, what the expected amount is going to be for each one of the unit or lot owners, et cetera. So the bottom line is just look at your governing documents, or more likely have your attorney do that for you. And they can let you know, one, whether you have the right under the documents to levy a special assessment, and if not, what your options may be. There's another option. If it's truly a large amount, depending on what your governing documents say, you may get a loan that is then paid off via a separate assessment or as part of your budget in the following fiscal year, because there are plenty of banks that will work directly with community associations and give, for larger loans, they'll give interest free for the first year or two, so that you really don't need to impact your budget for that year or two. It's just a small increase. And some communities have enough of an overflow, so to speak, that they can cover the interest alone. So I hope that answered the question.
It certainly does. I thank you very much.
You're very welcome.
That's
Thanks for calling.
So give her this, you know what, people, God, we are getting emails for this show from all over Florida, not just here in South Florida. So let's give everybody your toll-free number.
Sure. We can be reached at 1-800-974-0680. And that's any of our 4 offices can be reached through that number. We can also be reached at just the main number. Thank you for putting that up. The other number is 954-928-0680.
We're going to go to our first break. We're a little late on it, but that's okay. We're going to go to our first break. When we come back, we have more with our Community Association Law Show. Kay Bender-Rimbaum. We'll be right back.
Kay Bender-Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several Kay Bender-Rimbaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. Kay Bender-Rimbaum is also a well-known provider of free legal education for managers and board members. Contact Kay Bender-Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
Yeah, and we are back. This is the Ask the Expert show. We're with you every Thursday at 5 o'clock. This is the last Thursday of the month. We have the Kay Bender-Rimbaum Community Association Law Firm. Been with us for 7 years now. And you just keep writing and writing. If you've got a question, you live in an association, or maybe you're a board member or a management company, give us a call right now at 561-623-9429. That's 561-623-9429. We're going to go back to our questions. We're here with Alan Swartseed. Seed or side?
Side.
Side. I'm going to get it next time.
Got it, Steve. You're getting there.
Anyway, we're going to go to Candy in Boynton Beach. I'm trying to train everybody, Alan, to tell us if they're in a condo or an HOA. And Candy must have listened. She's in a condo.
Okay.
She wants to know who's responsible to repair a leaking pipe that is located between the floors of 2 units. The owner of the top unit or the association?
Well, I want to thank you for making this really easy for me and really difficult for you. You got to look at the governing documents. You got to figure out what's a common element versus what is defined as part of the unit. If that pipe, it's most likely a common element. So I will say the most likely outcome is that the association should be repairing it if it is a common element, which it most likely is if it's between the units. But there are, again, some wonky declarations that basically say there is no in between the units. There's the floor and there's the ceiling, and that's it. So the unit, anything in between is one person's responsibility or the other. Leaks that are coming from inside a unit or piping that that unit actually has full control over might be the unit's responsibility, meaning the unit above. But chances are the association is going to have to step in unless the unit owner is willing to take the necessary step of making sure that that pipe is repaired, and the association might be responsible. But again, short answer is you got to check the deck.
You're in Orlando right now, right?
Yes, sir.
I got take just 30 seconds out. There was a major shooting today in Orlando. And I don't know if you know about this, but just want to say give our prayers out to the families. There's been a lot of carnage from what I understand right there in Orlando. You guys always seem to get your share, but we just want to put our thoughts and prayers out.
Much appreciated, Steve.
Yes. Let's go to our phone lines. Let's go to Becky in Boca Raton. Good afternoon, Becky.
Hi, good afternoon. Thanks for taking my call.
You're welcome.
My question is twofold, if you don't mind.
Not at all.
We're in a HOA. Yeah, we're in a HOA, and one of our declarations, 8.04, says for our leases that there are no additional amendments or restrictions without 100% consent of owners. And now we're coming up for our annual meeting, and their board is proposing a change, an amendment to the declarations. They're listing it as number 8.25, and they're saying dual usage, the leases or rentals of a unit, and they're making some changes to that. So my question on that one is, if 8.04 says you can't make any changes without the consent of 100% of the owners or additional restrictions, and they're now proposing to make a restriction and putting it in under a different number, 8.25, would that be incorrect, to attempt to put in a different numbered paragraph and to change the usage allowed or rental or lease of a unit? Is that a way? Would that be legal for them to try and get around that paragraph because they know they can't get 100% of the homeowners in favor of making a change?
It might be. I mean, I'll be candid. I would need to review the rest of the declaration to see whether that 100% requirement applies to all amendments, whether it's just new use restrictions as compared to changes in use restrictions, or what exactly it provides. I could also see the argument if it is just, new restrictions that are prohibited without that 100% approval, that the new provision that they're trying to put in is somehow supported by an existing provision, meaning that it's not a new use restriction. So without looking at your documents, I can't give a straightforward answer, candidly.
Yeah, no, you're absolutely right. But it only appears in that specific 8.04 leases, where it says without the consent. Other ones, it's in the documents, it says it needs 2/3 majority only. But in that specific unit, particular item, it says 100%. And that,
I see what you mean. They're trying to create a new section so that 100% limitation doesn't apply, because the rest of the declaration doesn't require the 100%. Now I understand a little better. The bottom line is, in that instance, it would depend whether that provision absolutely must be under that provision. The change would need to go under, I think you said it's section 8.4 of your declaration. If the answer is no, then they might be able to add it in. If the answer is yes, it must be in there because that is the only provision that deals with leases already, there's probably not a whole lot I would be able to say that would support that change. But again, I'd need to take a look at the declaration to give you a straight answer. But my short answer is, chances are you'd need the 100% if it pertains to the same subject matter. But I can't give you a definitive answer.
Yeah. And my second part was in relation to architectural review requests. When you do a document, when you do a records request, in Chapter 720, where it says all other written records of the association not specifically included in this subsection, which are related to the operation of the association, you can then request it. So in the past, we had a property manager who did provide architectural review requests. If you requested to see via certified mail return receipt to see the information regarding a change or modification that was made to a home or landscaping, they produced it. This new property management company doesn't want to produce it. So I'm just wondering, would that section cover that? Should they be in reality? Should they make any architectural review requests available upon request via certified mail?
The short answer is yes, they should be making them available. I mean, the statute is fairly clear as to the catch-all that you mentioned. Any other documents related to the business of the association is pretty much what you have to give out. Now, there are some exemptions and exceptions to that are also in the statute. Architectural requests don't really fit into any of those categories of exemptions and exceptions that are listed. There may be redactions for personal information that's in those architectural review requests, but I'm not aware of anything, and I would suggest that manager provide the legal authority that they're relying on to say, we're not going to allow your community to share that information with the members upon proper request.
Okay, excellent. Thank you very much.
You're very welcome.
Clarification. Great stuff. Okay.
Thanks,
bye-bye.
Becky. Good questions. Okay, we have a line open right now if you'd like to call into the show. The number here is 561. Write this down, 561. See, look at that, how I give people time to write it down. That's so fine. Now I just lost my place of all times to do that. 561-623-9429. That's 561-623-9429. If you have a question for Alan, this is the best time to call in. Let's go to Dean in Delray Beach. What experience or qualities should we look for when voting for a president of our board?
Excellent question. So
yeah.
one that you may want to look for is business experience, because 90% of the people I encounter that are on the board of directors have zero experience in business. They may have worked for a business, but I'm talking about people that have run a corporation, which, by the way, your association is. You're a not-for-profit corporation. Just because you're not trying to make money for this association doesn't mean that you're not running a business. Keep in mind, these condos, HOAs, co-ops, they're all subject not only to the pertinent chapter of the Florida statutes regarding the community association, they're also subject to Chapter 617, which is the Not-for-Profit Act. So you want to make sure that person has either, business knowledge or business experience. Another thing that I look for is, frankly, a mediator is actually a very good person to be running your board, because there are not infrequently arguments between and among the board members where, you've got a board member that is taking over the whole community. And, I've got one right now where we're representing a very rare case where we represent several individuals who are trying to overturn an election on the basis that it was improper. But the real reason they want to do that is because the person that is operating a couple thousand lot community is basically directing everything for the entire community and won't let anyone else speak. So you want to hear, you want people that are open to ideas, that will listen, that will take criticism, because there will be plenty of it. And bottom line, just people that are I don't mean street smart, I mean book smart, and who are willing to listen to ideas. Those, honestly, I would love to see someone who is knowledgeable in business, but I think that someone who is open to ideas and frankly open to listening to their manager and their attorney is almost more important, and willing to go out and spend the time to get the guidance to do things the right way.
It's amazing. It's a tough job, especially as president. And a friend of mine is a president in Dallas. He can't go anywhere without people stopping him, residents stopping him. But, you're right. Do you think that position will ever be a paid position?
I mean, there are some instances, I'll put it this way. I think it should be, but I think there should be qualifications that you need to meet more than just taking a board certification class. I think you should meet certain qualifications so that you're justifying the pay, and it should be capped by the Florida legislature. If you wanted someone to manage and maintain your community up to a certain standard, that's why you hire a property manager.
Right.
And that's why I think, yes, these are volunteer positions, and there's a reason for that. That said, I think there is definitely a benefit. There's one person that I work with very frequently in particular who is, he's a 40-year attorney in Florida, worked with the DBPR for years, and practiced in real estate, and owns 100 lots and units throughout Florida with a couple entities that he operates. That's a guy you want on your board. He knows what he's talking about. He's been doing it for several decades. That's the guy you want. That's the guy I'd be willing to pay if this were my community we're talking about here. But I don't think that it's going to become a regular thing that people get paid for this service.
Let's go to our phone lines. Let's go to Stephen in Boynton Beach. Good afternoon, Stephen.
Good afternoon.
You have a question for Alan?
Yes, I have a question. I live in an HOA community, and we have our annual meeting coming up next month. And we've been the board president makes up the agenda for the annual meeting. And in the past, people have tried to add to the agenda at the annual meeting because it's a meeting of the community, not the board. And she keeps rejecting those requests that something be added to the agenda. Does the agenda have to be approved by the community at the meeting?
I mean, the agenda doesn't need to be approved by the community. It's something that the board will generally get to decide on. But if the membership has issues that they desperately want addressed, there is a statutory method of obtaining a member meeting. It's, you look in the Florida statutes under Chapter 720 for special meetings of the members. And there is, a form that you can fill out, essentially. It's basically a petition. When you get a certain percentage of the members together and everyone signs something saying, hey, board, we want this addressed. You can basically, you can't immediately schedule your own notice, but if the board doesn't do so, you might be entitled to just go ahead and schedule a notice. And if the board of directors is not doing what the members think they should be doing, then you can either, address that at the election by voting them out, or if you think that they're doing something wrong, you can try and challenge it in court or in arbitration, or potentially, you could recall the directors that you think are unilaterally deciding things without getting member approval that should be approved by the members, or without getting board approval that should be approved by the board. But the short answer is no, there's no obligation of the board to put items on the agenda unless that special meeting request has been done. And either way, it's not going to be something that gets placed on the annual meeting agenda. It would be a separate special meeting for the purpose of addressing the items that you've listed and that the sufficient amount of the members want addressed at that meeting.
Even though our documents say at the annual meeting we can discuss other items that may legally come before the board, before the community.
Well, that doesn't mean that those items have to be on the agenda. It's a different story. You said that the board would not put it on, or the board president refused to put those items on the agenda. If there is an open forum session, so to speak, that is required under your particular bylaws, then the board has to provide it. So if they're not doing that, then that would be another basis for you to raise a claim against the director or directors, or more likely against the association. But again, it's one of those things, like I've said repeatedly earlier, I'd have to look at your particular governing documents. There's nothing in the statutes that requires an HOA or condo. Well, okay, let me rephrase. That requires an HOA board of directors to place any particular items other than the election on the on the agenda for the annual meeting.
Thank you.
You're welcome.
That was a good call. We're going to go to our last break and give everybody the toll-free number.
Sure. 1-800-974-0680 is that toll-free number that'll reach anyone within our firm.
Yeah, I got to tell you something. You're kidding. I'm getting a lot of new text. People are enjoying your show, bro.
I'm glad to hear it.
Let's go to break. We'll be back with
All right.
Kay Bender-Rimbaum.
Kay Bender-Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several Kay Bender-Rimbaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. Kay Bender-Rimbaum is also a well-known provider of free legal education for managers and board members. Contact Kay Bender-Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4TV with your hosts, Steve-O, Sophia, and their expert guests.
So that Kay Bender-Rimbaum does a lot of classes, educational classes during the month. And, we're scrolling them now on the TV screen, but there's many of you who are listening on radio. Just let me tell you that on February 27th at 2 p.m., there'll be a Zoom, Should I Pay or Should I Go? Now, I wonder, was that Rimbaum's idea?
I'm taking credit for that one. That was me and Jeff Solomon figuring out what to call the assessment class.
It's a great one. March 2nd at 9 a.m. in Fort Lauderdale, Sheraton. There'll be a town hall, Florida Condo Reserve Laws. And I've been to the town hall. They're wonderful. March 15th, HOA board certification. March 29th, condo board certification. It'll be via Zoom. The best thing to do is go to your website, which is, let me see if I can do this, www.kbrlegal.com.
You got it. Well done.
No notes. But there's so many great articles on there, and go there and you'll find out all the different classes they're holding. Anyhow, let's go back to our text, or people who've texted us in. Here's Jill in Boca Raton. I live in a 55 plus community with an association. They are all with the association because the 55 plus are set up that way. I don't know what she meant by that. I find the dues very fair, even if I don't use everything included in the dues. I guess she heard someone say that they didn't think dues are fair, and she's just saying they are. Is that how you take it?
It sounds like she's not using things and is considering whether or not she's entitled to some kind of discount for that.
Okay.
The short answer is nope. You live in a community, you deal with whatever the community has. If you've got a separate recreational club or recreational facilities that the community offers for rent or to pay an annual fee or something of that nature, that's a different story. But the fact that you're not using the maintenance, the things that the association is maintaining and charging you for the maintenance of doesn't mean that you don't have to pay for them. So that's the quick answer. Steve, if you don't mind, I'd also like to mention we have one other class of board certification for condo and HOA that I'll be teaching for the first time in our Orlando office on the 28th. We've still got, I think, 2 or 3 spots available. And frankly, that space is limited by how many people fit in my conference room. But if anyone is interested, that's another one. You're welcome to check on the KBR Legal website.
Okay. Well, we have about 3 or 4 minutes left. I don't know why we're getting this echo in the background. Anyway, this is Ron in West Palm Beach. If we have no quorum, how does the board do business?
Well, that's a good one to possibly end with, because it's a tough answer. I mean, you cannot have a board meeting or a member meeting without a quorum. He specifically asked about how does the board do business, so I'm presuming we're not talking about how do the members vote on things, because the answer is you can't. But when it comes to the board, there are ways of getting that quorum rather than having in-person meetings. The board can hold a meeting via Zoom. You might have to provide, or when I say Zoom, what I mean is any technology. You can have a conference call where one of the directors is sitting inside the community somewhere so that you're within the limits of where you should be holding this, so that the members still have the ability to attend the board meeting like they are authorized to. But you're giving the opportunity for the directors who might not otherwise be available. For example, if I was on my HOA board, there is absolutely no way I'd be attending a 5 o'clock board meeting in person, because I'm usually still in the office or I'm driving home. Now, I'm fortunate that my office is 10 minutes from my house, so I might be able to make it for part of the meeting. But Zoom, conference calls, things of that nature, they're offered for free, and they can be an avenue whereby it becomes easier to reach that quorum. It's not everyone has to be in the same room at the same time. If you're not able to do that, but you know that everyone agrees on these topics, I would normally recommend something that I can't recommend because you're not able to get a meeting together, which is to make the decisions and then ratify them later on, knowing that the board members are unanimous on that decision. What you can do, and again, remember, before I mentioned, HOAs and condos, co-ops are subject to the Nonprofit Corporations Act. One of the things that act allows is to actually have a written unanimous vote, is essentially what it is. If the directors are unanimous in their decisions, they can just sign a piece of paper that essentially says, yep, we're all good. We all agree we're going to do it this way. And then you just place that piece of paper in the association's official records, and it's statutorily the equivalent of having a board meeting and voting at that board meeting. So there are things you can do to facilitate having that board meeting and reaching that quorum. But if you really can't reach the quorum, unfortunately, one of the only options you're going to have, other than having new people enter onto the board who can actually attend these meetings, is going to be to have a unanimous decision that is done in writing.
Well, I got to tell you, we just noticed we had several people in comments, which we'll have to do next week when Robert K. is on. Alan, we thank you so much tonight for joining us. Let's give everybody your phone number one more time.
Sure, and thank you for having me, Steve. That number is 800-974-0680.
Hey, maybe we can get you to be a regular last Thursday of the month. K. Bender Rimbaugh. And we'll be back with you next week we'll be K. Bender Rimbaugh next week also with one of the senior partners, Robert K. Everybody have a wonderful weekend. Alan, thank you so much, bro.
Thank you.
we'll see you next week.
All right.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.